Hello and very welcome to this webinar. Today we are going to talk about how telecom regulation in Europe impacts us as an automotive IoT connectivity provider as well as the car OEMs. In today's cars, there is a need for what we call in-car connectivity, meaning connectivity for all the entertainment, music, browsing applications that we see in today's cars, powering all these big screens with content and creating a very new type of end-user digital experience. And for clarity, this webinar will not contain any legal statements from our side. It will rather be a discussion about this quite hairy topic. And my name is Marie Högberg, and I'm heading up the automotive team within Telenor Connection, and I got the honor to be the host today. And with me, I have my colleagues Lynn and Dominic. So please introduce yourself.
Yes, hello. My name is Lynn Gustafsson, and I work as a legal counsel at Telenor IoT. I've been working with the telecom field for about a year, and my role then as working with legal and regulatory within telecom and for a connectivity provider is ensuring compliance and that we have the correct or necessary compliance measures in place when providing these kind of connectivity services.
Hello, and my name is Dominic Lindner. I'm helping out here with regulatory and legal questions when it comes to automotive IoT. I work in telecoms regulations for more than 10 years now, with a lot of experience and expertise when it comes to automotive IoT and in-car connectivity. In the past, I have rolled out such services in over 25 countries. So I'm really looking forward to today's discussion, and maybe we can shed some light on all these questions the guys outside might have.
Yeah, thank you so much. I agree, very much look forward to this. And to kick off, as we all are aware of, cars of today are said to be or are turning to become software defined, which means that there is a completely new landscape that we need to understand also from a connectivity perspective. But cars have been connected for quite some time, maybe already over 20 years. So there has been connectivity in cars before, but still, what is the difference now, and what trends do we see on the market? So to my first question, I mean, there's quite some complexity around when in-car connectivity is still seen as maybe M2M versus an electronic communication service. So could you explain a little bit why this matters and what obligations that we would face given these definitions?
Yes, and I think this is a very good question. It's very fundamental for this whole discussion and knowing what obligations one have to comply with. It all comes down to definitions really, in not necessarily only telecom regulations, but regulatory in general. And when it comes to the distinction between M2M and electronic communication services, I should go back to say that the legal framework that becomes very important for these kind of obligations is the European Electronic Communications Code. And in that code, I'm going to refer to it as the code going forward. But in that code, an electronic communication service is defined by some subcategories of communication services. One of them is M2M. And this kind of traditional M2M is one can say, automated backend connections. One can think about telemetry or remote diagnostics, e-call, these kind of connections that require no to very limited human interactions. And they are usually connected to a lighter set of regulatory obligations. And this is what we've seen mostly in the past. When the connectivity then moves towards a more interactive connectivity usage where the driver or the passengers can can interact with the connectivity, perhaps through browsing or streaming or gaming. We don't necessarily still, we're not necessarily in the M2M sphere anymore. And it might move towards something that falls within one of the other subcategories of electronic communication services. And they can be then combined with more extensive regulatory requirements. And those kind of obligations could then be a need to get the general authorization, and that means you have to notify the provision of the service in a bunch of member states where you intend to operate. It could also be security regulation that you have to comply with, and transparency rules, and sometimes also net neutrality obligations. It's all once again depending on what your service would qualify as. And this is of course important for the car makers to know when providing a connectivity service.
Yeah, for sure. And to dive a little bit deeper into one thing that you mentioned something called general authorization. And Dominic, now I turn to you. For us as an automotive IoT connectivity provider, we might fall under the general authorization regime. So could you explain a little bit what that means for us as a company?
Yeah, of course. Like we have just learned so nicely from Lynn that there is the code, yeah? And if your service falls under a specific category, the code puts a lot of things on you. And one thing is so-called general authorization regime. What does it mean? Think a bit about a driving license or something like that. So driving license would mean particularly you need to follow some rules if you want to drive on the streets. And the code sets out some specific rules that you just in general need to follow if you want to use the road and participate in traffic itself. And that's more or less the analogy you can have in mind. The general authorization regime means you do not need necessarily to have a permit in every market that you want to follow. Rather, throughout the member states, there are some particular rules you need to follow through. And one of these things that Lynn has already mentioned could be a notification. So that means if you want to provide a specific kind of service, and you need to understand what this kind of service is, you need to go to the regulator and tell the telecoms regulator to notify them, hey, I'm going to provide this service. But not every member state has this in place. There are member states who said it's not necessary, but still it means you need to follow the rules, Lynn has mentioned a couple of them, put out under the general authorization regime. So important to understand is here, there might be a market that does not put a notification obligation on you, but this does not mean you can say there are no obligations at all. There's just no notification obligation. So notification is something very, very interesting we need to look at. And in general, it should be harmonized. So you could think, yeah, okay, I will maybe send out something to all the regulators. But if you dive into it and you start talking to all these regulators across the European Union, it gets a bit more complicated and hairy than you might think.
Mm-hmm. And how hairy? I mean, how tricky is this process? I mean, is it just? I mean, I think you said it already, but it isn't enough just to send a letter. And then you are done?
I'd say not in general. In our experience, we've seen that some member states have simple procedures like that. It can be enough with just registering on an online portal or downloading a template from the authority's website and then submitting that. But other member states have interpreted this differently and combine these notification requirements with a bunch of following requirements. It can be, for example, we've seen a requirement on local presence, or they have to have a national tax ID. It could also be follow-up questions on number ranges or data processing. So I'd say that the member states have interpreted these authorization or these notifications very differently, and so it varies. Yeah.
I see. So it
Maybe to add on this,
Yeah.
right, that because Lynn and I have been now investing good amount of time here at Telenor Connection to look into this and to talk to regulators all across the union. And it was really way more complicated than we anticipated. Yeah. And it can already start with language barriers, right?
exactly.
So for us, not speaking all the 11, 12, I don't know how many languages across the union, suddenly you might have a dialogue and there are language barriers and you do not really understand. Or one could even say that in the code we have fixed kind of services like the logic has. This would be a subcategory that Lynn mentioned. That would be a subcategory. So we thought maybe we just figure out which subcategory from the code here, but regulators interpret this very differently. So a service that you think in one market qualifies as the following could be interpreted again differently in a different market. So it really takes time, resource, and a lot of expertise and experience to navigate only this one requirement that is set out under general authorization regime.
Exactly, and also after having notified, that can also trigger other obligations depending on which member state you're operating in. So that could be in certain states that you have to cooperate with law enforcement, or you have to do those kinds of things, and that varies as well depending on which member state you've notified in and what they see fit with their notification requirements.
I see. And all of these topics that we discussed today, we deep dive into in our regulatory guide that we just have released. And going a little bit into this regulatory guide, there are some areas that we have looked into in particular. And if we now leave a little bit the authorization regime and what is tricky about that, and talk about something else. And now I'm thinking about data retention, because there are also obligations around this, and I guess they also differ across Europe. So could you give some examples of this and what to consider here as well?
Shall I start? Yeah. Okay. Because you mentioned, just to make it clear, you said let's leave the general authorization regime. We are not leaving this because we are still under this regime, and there are multiple things you need to consider because you fall under this regime. And if you have to confess, to argue, whatever you want to use as a term, that this in-car connectivity service you're particularly talking about falls within this, and you want to offer it in many member states, you might find data retention as a requirement. And what does it mean now? So in the past, the European Union tried to put a harmonized framework on all of us, which would be, for a company that provides the service in many different markets with a centralized IT system, however, would be good. Because then you could think, okay, there's one rule I need to follow, and it will be like this in all markets. It's what the European Union is trying to do again at the moment, because it failed, because the European Court of Justice ruled out that this is against what privacy matters and what we consider to be okay. This, we retain all the information about everyone. It was a hairy topic. So it got revoked, this idea of a harmonized approach, but the member states were not so happy with that. So what we see today, a lot of member states still have data retention requirements in place if you provide such a connectivity service, and it's very different from member state to member state. So you might find that it starts with the question, what kind of data do I need to retain? Is it data about the person that uses the service? So like name, address, or whatever. It's called subscriber data, but yeah, doesn't matter. Or is it something about the communication of this person? Like, when was this person online? How long was this person online? Maybe what did this person do? This is one of the biggest questions you need to check in every market, because some markets or some jurisdictions will push on you that you need to have information what what did this person do online, where others say, no, 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 this is highly illegal and not okay from our perspective. And it puts a lot of effort on you, especially if you operate a centralized platform. I mean, makes sense, right? You're not starting to build one platform for every market. You have a centralized system, and all this data flows into the system from all the states. But you cannot apply one logic on all these data streams, right? You need to see this is a data stream more or less from Sweden, or this is one from Germany, where I'm from, right? And then you need to apply different data retention logics to it. And I would say it's no rocket science to do that, but it carries that you need to investigate very carefully these requirements. These requirements under constant change, because someone will sue against this, and then there's discussion, new court rulings. So it takes a lot of resource to stay ahead on this topic. And of course, you need the technology expertise of people who can build systems and operate systems that then comply with all these data retention requirements in a secure way, and still keep requirements. And I don't want to dive into that now, but GDPR has sometimes a very different perspective on that. So you need to walk with a very thin line and thin path to be ahead and on top of that.
I see. So data retention is important, and it's important to understand how to handle that across the different member states. But something that we hear a lot in the industry, and our customers sometimes talk about, the car OEMs, is KYC, know your customer. And is that the same as data retention? And sometimes there is like some kind of authorization of end users being discussed, or are these different obligations? So enlighten me a little bit, because it's quite confusing for many.
No, I understand that, because they are linked, those two. I would, however, say that they are different obligations. And to put it simple, KYC, or user identification or user verification, is the process of identifying who is the actual user of the service. And data retention, as Dominic explained, it's rather about collecting the data, the metadata, which could be IP addresses or connection timestamps or location information. And those two sets of information are then used to be able to enable then authorities to link data to an actual individual. And the purpose of this is basically crime prevention. So it's a limited scope within this is used. It's not used for just curiosity. And then, since this is the purpose of it, some countries have introduced further SIM registration laws, where they, for example, they condition the SIM activation with having the user have presented an ID, for example. But these kinds of SIM registration laws are also pretty controversial, and some countries have repealed them after having considered them ineffective. Some countries never even introduced such laws in the first place. And as Dominic mentioned a little bit, some also, like critics, can argue that this is almost some type of surveillance, and that it's not not necessary. So back to the question, two different obligations, but working together and designed to be, complementing each other. And why this is important for the car makers to know as well is then that even if they're partnering up with a connectivity provider and not then dealing with the metadata, they may still have to obtain this user information and then be able to collaborate with the connectivity provider should there be a request from an authority to be able to provide this information. So it's important to be aware of, and also know how to separate these kind of obligations and be able to cooperate efficiently.
And to break it down, right? This sounds super complicated and scary, and so many things I need to do. Yeah, of course, there's regulation and laws you need as a provider to comply with. but there are also very creative and effective ways how to apply with them, right? Take as a KYC or user verification.
KYC, if we didn't say that before.
Yeah, know your customer.
Yes.
It means that you cannot provide this kind of service without the user providing personal information about themselves. They need to provide their name, address. Yeah. By the way, very significantly across the union, if it exists in general, and if it exists, yes, what kind of data? So you need, in theory, individualized user journeys for each market again. Let's not dive into that. What I wanted to say is there are very smart and good ways how we can create this very seamless for the user. One, even if you would, as a car maker, partner with a connectivity partner, right? And say, can you please, you take care of this, does not necessarily mean that the driver, passenger needs to leave the system of the car maker. The user journey can still look like the car maker's one, and you can embed it in a very smart way. I think that's something you might maybe tell later, or I think you're working very hard on, that the car maker stays in control of the user journey. It's a car maker branded experience, and you can still offload to a connectivity partner and having an excellent experience for customers.
Yeah, true. We consider that this is very, very important in the solutions that we provide within Telenor Connection in this area. Especially for myself, I worked on the car OEM side as well, and I know the importance of really keeping the user in the car's user experience ecosystem, so to speak. So yeah, it's really good that there are a lot of creative ways out there how to handle this in a good way. So now we've talked a little bit about the general authorization regime, what does that mean? And we have deep dive into some of the obligations, as for example, the data retention. Now we talk a little bit about the SIM registration of your customer, user verification, more or less, finding out who is the user of this. Now let us go into another one of the obligations under the general authorization regime. And you mentioned this very earlier, Lynn. And it's the lawful access, which also is a big topic, and especially now with the new e-evidence regulation coming. So what does this mean for car manufacturers, and could we end up directly involved in this as a provider? And share us some insights, please.
While being afraid that Lynn might slap my hand because it's a wrong term I'm going to use, but it's something that also flies around when talking about this. It's called lawful interception. Yeah. So what I'm going to talk about is a bit more accurate now, lawful access, but some of the people might have heard about this under the terminology of lawful interception. But just that you mean it's very closely related, and that you say, hey, what is this? Okay, lawful access, what does it mean? So we learn, like Lynn explained very nicely, there's user identity, user information you might need to collect. There's meta information about the communication itself you might to collect and to retain. So why you do this? Because an authority can request this kind of data in case they investigate something or there's a suspicion and they want to know more about that. Simple example to simplify this a bit is like someone downloaded a movie, and you do not know who this person was, but you captured an IP address and a time when this happened. So you try to figure out who this IP address belonged to. So all this telecom information is playing a very active role in police investigations. And lawful access means that police or other authorities are allowed to request such data in case of a suspicion for further investigation. In theory, for someone who operates in their home market, like Telenor here in the Nordics or something like that, it's very daily business, right? Because you provide a service in your home market, you know all the authorities, there are established systems to that. It could be an easy thing. Now we are not in this field anymore, we are this cross-border services, right? Suddenly you provide these services in so many different markets. So there's so many different police authorities who might be interested in this data. And if you start providing such services, you have also the obligation to comply with this. You cannot just say, but I'm not here. No, you start providing these services here in this country to our end users. So we are entitled to that. And so You need to have processes in place. You need to have to understand all the requirements, who can request this data, what kind of data can be requested, how this data needs to be transferred, what is the deadline to this. So there's a lot of requirements and questions connected to that. Now, e-evidence regulation, so this always existed, right? This is nothing new, but now there is new evidence, e-evidence regulation entering into force, and this tries to make this a bit easier. Think about you go with your car on holidays to Italy, right? And I'm a German guy, I like to drive fast. I have always a problem with sticking to the speed limit, so I get a picture as a wonderful memory because I was driving too fast. And in the past, it's not 100% like this, but it's a good analogy, I think. In the past, it was like that the Italian authorities needed to go to the German authorities to say, hey, can you help me figuring out who this license plate belongs to? Who is this person? I want to find this person, yeah? And this is going away. They can approach like the register of license plates, so to say, they can approach the providers now more or less directly, right? They can we jump across this, and suddenly you have a lot of authorities that could come to you and want something from you. Our recent investigation, because we prepared ourselves here at Telenor very well for this, and we have just checked all our processes, but it's more or less over 500 authorities from the European Union that are theoretically entitled to come now to us and ask for this. And it takes a lot of focus and resources to stay ahead of this, I would say.
Absolutely, for sure. And as you say, providing all these services across all these different markets, that is required to serve this type of vertical. So, yeah, we need to find ways to manage all these 500 then.
We do.
Yeah, great. But let's say, we see, given the solutions that we build, we see that we can provide these services, the in-car connectivity services, to the end users of the car in our name. But if we do that, does it make us directly responsible for like consumer contracts and complaint handling? Let's say that a user is not happy with something, and all the documentation around this. Like, what is our, what are the things we need to think about also in this respect?
I think it depends is the easy answer.
The legal answer.
The very legal answer is it depends. It depends on how the service is designed and offered. And if the whole connectivity part of the service is branded by the car maker's brand, and it's also built through the car maker's brand, then it may be that the regulators will consider the car maker the ultimate connectivity provider, even though there's another setup between a connectivity provider and the car maker in question. And if that is the case, then there is other like obligations that are triggered that the car maker then have to comply with, and that could be making sure that they have standardized consumer contract summaries for the consumers, as you mentioned, complaint handling and dispute resolution procedures, and they may also have to, of course, deal with the information to the end users about their rights and their points of contact. So they could become responsible for that, but it can also be avoided by a separation of responsibility and a clearer delegation of responsibility between the connectivity provider and the car maker. So done right, as Dominic was talking about before, then the car maker can still own and control the entire user experience while still offloading the compliance burden to a connectivity provider that is maybe a bit more up in that field and on top of those questions.
Yeah, I see. But given all these like regulatory hurdles, like all the things we have been mentioning here that are like, for car makers, I would say, that are experts in building cars, completely new areas. Do you generally advise car OEMs to become registered telecom providers themselves, or should they rather work with a a company like us. Any views on that or thoughts that you would like to share?
Maybe let me be a bit provocative to bring a different analogy to the table. So would a car maker start, or you can ask the next time you talk to one or meet one, you can ask them, would they start building the road network themselves? Yeah, I mean, they build excellent cars and have good and safe driving experience for sure. But like, do you want to do that? Would you start building the roads? Would you start to take care of road safety and speedometers and maintenance of the roads? Or is this rather the job of someone else? Yeah, because I focus on cars. Of course, maybe building roads is a bigger project than what we are talking about. I don't know. I'm not so good in infrastructure. However, it depends a bit on the general question: what is your strategy? What you want to do, right? So you can do that definitely as a car maker. I mean, they have so much experience with compliance, and there's so many laws and regulations they need to stick to. Do they need another area they need to focus and stick on? I don't know, but for sure they could probably do it if they invest time, resources, and want to learn about that. However, as we already mentioned today, this is also a good strategy to partner with someone who has all this experience, who holds licenses in all the markets that you might need under telecom law. And therefore, I think it's a rather discussion of all these factors, what you want to do and where your strategy goes. In the past, I have seen in the markets mostly that almost all of them opted to partner with an experienced connectivity partner who helps them figuring all this out, being compliant there, and offering this in-car connectivity in a tandem construct and together and making a great digital experience in the cars.
Mm-hmm. So what we more or less say that both options are possible, and it's really up to the car OEMs to define their own strategy. But what we see right now is that most of them decide to partner up with a telecom provider that can help and support in this area. Yes. I actually don't have so many questions left, but I actually have one question, and it's about that. The regulatory guide, it mentions that the European Electronic Communication Code, or the code as we refer to it, is up for review. And there is also an ongoing dialogue about numbering resources. So how do you think that car OEMs should plan their strategy to stay compliant and future-proof, given the discussions and changes that are under review?
A common topic when talking about these kind of compliance issues in the telecom field is the fragmentation of the regulations and the different interpretations of the regulations. And this comes from, or my view is that it comes partially from the Electronic Communications Code being a directive, which means that all member states can interpret the directive and then incorporate it into their own national legislation in a way that they see fit. And this is part of the reason why all the different member states have different requirements and various obligations connected to the different kinds of services, and also defining the services a little bit differently. And by this being reviewed now and having an upcoming Digital Networks Act enter into force, hopefully, that DNA, Digital Networks Act, is going to be a regulation, which, as opposed to the code being a directive, means that it's directly applicable to all member states. And the ambition then is to create a more harmonized and cohesive regime where things are a bit more standardized, both spectrum authorizations and perhaps numbering questions as well. Maybe even we'll see that the notification regime will become a bit more harmonized than we've seen so far. Another reason, of course, why the regulation today is a bit fragmented and blurry is because technology, as we know, develops way faster than legislation. So this may also be a chance to try to fit new services into the legislation where it's today maybe in gray zones. And why is this important for the car makers? I would say that this is important for the car makers because being compliant with the current regime today and positioning oneself strategically already today is obviously going to make the transition to an upcoming new regulation easier and more seamless. So I think it's strategic, of course, to make sure that you're in control of the compliance obligations that exist already today for the transition to be smoother than when it's time.
I see. And simplification in this area, I think we would all appreciate, at least the providers like us working towards in a cross-border scenario, covering several markets and car OEMs selling cars all across the world. So that is, of course, something that I think we would appreciate. But anything you would like to add, Dominic?
Yeah, because you mentioned simplifying, right? So I personally would not advocate for deregulation. Yeah, I mean, there need to be rules out on the street that we can listen to how we have to drive, right? Otherwise, there would be all over accidents all the time. No one wants that. So deregulation, I would not argue, is necessarily necessary, but to simplify some things could really help, just because in the end, our overall vision, I think, is something like a single market across the European Union. So here's a good area with simplification to make a big step towards this common goal, and in the end make things better and easier to handle so that one can focus on operating a business and monetizing and getting the economy up without violating consumers or harming their rights or abusing them or something like that. I think there's a clear path how you can achieve both and move forward here on this overall agenda.
Yes, good. So maybe that was then the last word in relation to this topic, and I would say we are more or less done for today. We have in this webinar talked about the introduction of what we call in-car connectivity, which is really the connectivity powering all the applications on the big screens in today's modern cars, and how the introduction of these type of solutions and user experience setups really impacts how you need to think about telecom regulation. And today we are focusing here on Europe. We talked about the general authorization regime. We talked about data retention obligation under that regime. We talked about the importance of managing end user data, SIM registration, and know your customer, etc. And we also touched upon the lawful access obligation. Finally, we touched a little bit upon the end user contracts and how to build a compliant end user journey, the importance of cooperation between the car OEM and their chosen telecom provider, and also said that it's actually possible for car OEMs to take on these obligations themselves if they want to. Everything is a question about the strategy. Just choose. So with that said, I would also urge you all that have been listening and have further questions to, first of all, download our regulatory guide in this area if you haven't done it already. And of course, we would really look forward to discuss these topics even more in person with you. So feel free to contact us. And thank you so much for listening.